with another episode of Pot Talk TV, and we're going to go on with a little further about our court cases. But first off, I'd like to say this show is dedicated always to freeing all the marijuana prisoners, and we want the arrests to stop and no more going in. We've done a lot of shows on that, and we're going to bring you a little bit of an update on our battle with the courts in Hurley, and to show, we keep trying to show you people out there in Ulster County and down in New York City how corrupt the courts are in Ulster County. We don't do these, read you these cases, and so you'll say, oh, poor Joe and poor Paula, they got arrested and they're fighting a court case. We're not looking for you people to say poor Joe and poor Paula. We're using our case as an example to show you people out there what they're doing to us, they're doing to everybody that goes into these courts, and how you know no one gets justice. We're using our case as an example to show you people how corrupt the courts are and how you don't get any justice or any due process in the Ulster County courts. They're all corporate courts. They're there to make money off you, and they're hurting you like chattel and doing what they want with you. And it don't matter to them what law you cite. All the courts in Ulster County are criminal organizations, operations, and I'm going to prove to you exactly what I'm saying. We filed this paper, and this is our ongoing battle with Hurley Court. We filed this paper, and we were saying we wanted to review the sentence and have the sentence overturned because everything they did was illegal and unlawful. All right, so we put, please take upon notice that the above, I'm going to skip that, that's just an introduction, that claimant may be heard, that we're the claimants, for an order to vacate judgment of conviction pursuant to Procedure Law Section 4430, and for an order to renew pursuant to Criminal CPLR 2221, and for such other relief as the court may deem just and proper in the circumstances. Please take further notice pursuant to CPLR 2214B, you are required to serve your answer affidavits on the undersigned no later than 2 days prior to the date set above in the submission of this motion. So what we're saying, that the prosecutor was supposed to give us an answer to what we had put in within 2 days before we were supposed to go to court. And that's just the front page. Okay, now, I, the claimant, alleged defendant in the above captioned matter, and I make this affidavit in support of a motion to vacate and a motion to renew. What I'm saying is vacate the order, the judgment, and renew, which is a normal legal thing that a lot of lawyers do. This deponent was falsely convicted in violation of possession of marijuana, in violation of Penal Law Section 221.05, and additionally a tail lamp violation in violation of after a bench trial. Now, I'll admit that my tail light was broken, but the police officer should have only gave me a ticket for a tail light out, not arrest me and then violently arrest Paula and mistreat her. None of that was legal. All right, but anyway, this deponent did not enter a plea in a matter where after the prosecutor and the court failed to establish personal jurisdiction over this deponent, that's me, and further failed to establish subject matter jurisdiction prior to a bench trial in the matter. What I'm saying there is what they did was basically illegal. They didn't have jurisdiction. If you don't have jurisdiction, you can't try somebody. This court mailed a letter to the deponent, that's me, erroneously, stating that this court accepted a guilty plea from it was a not guilty plea from deponent. The court erred by conducting a trial in the matter prior to and without a plea having been entered by deponent. By allowing the prosecution to default in response to any of the deponent's pleadings, the court failed to require the prosecution to respond. The court failed to enter orders on motions and failed to enter a judgment of conviction, all of which should have contained findings of fact and conclusions of law in violation of CPL 440-37. Judge Michael Jordan demonstrated judicial bias against this deponent by prosecuting the case from the bench and by failing to require the prosecutor to prosecute the case. Judge, did you get that? We're saying that the judge prosecuted the case from the bench and the prosecutor didn't do his job, just kind of stood around, which a judge is not supposed to prosecute. He's supposed to be an impartial, unbiased referee, which actually, obviously, Michael Jordan isn't.
He's not supposed to be a process server either.
Right, we'll get to that. Judge Michael Jordan demonstrated judicial bias by failing to dismiss the case when the police dashboard camera, which all you people have seen many times, clearly showed that the police officer acted under color of law by arresting Joseph Barton, Paula Gloria Barton, and by searching the vehicle without a warrant before there was ever any evidence of a crime. So you people have all seen the dashboard camera where he arrests me and then arrests Paula and never found any crime except the supposed smell of marijuana, which if you watch the dashboard camera, he doesn't find the pot until it's in the back of the car under a blanket in 3 bags that were all wrapped nice and tight and stuffed under a blanket. Now that cop says he smelled...
And it's a miserable half ounce.
Right. Well, it was... Now that cop said he smelt that marijuana, which...
Super nose.
Right. I'd like to see his test, like they tested dog smell. I'd like to see his test to see how good it is.
Bionic nose.
All right. 8. Michael Jordan failed to give honest service and violated his oath of office by not protecting the opponent's rights under the Bill of Rights, under the U.S. Constitution, and under the New York State Constitution. Now, a judge is supposed to protect the rights of all parties in court, both the victim and the defendant, which there was no victim in our case. So as the supposed defendants, he was supposed to protect our rights, but not through any of this trial did he do that. And what I'm pointing out in our trial, I'm pointing out these things, what they did to us, but what they did to us, they do to everyone who comes before them. And actually, because we know enough about law, we actually get a little bit more where they just step off. If a young kid going into these courts don't have a chance, they give him a lawyer that just sells him out. And if the kid tried to defend himself, if he didn't have knowledge of law, they just walk all over. And the judge would, normally, if he was a constitutional judge, he would be protecting the kid's rights, not let the prosecutor get away with the stuff that they let prosecutors get away with.
If they talk at all.
Right, right. And even if the judge knew, well, this kid don't understand his constitutional right, but just because he don't understand it doesn't mean it doesn't exist, and doesn't mean that it's not the judge's job to protect that right. When you go into court, they try to make it like, well, if you don't know you have a right, then we don't have to observe that right or protect that right. which is everything which is against our Constitution, every kind of way. It's judges ruling as tyrants in violation of the Constitution. All right, wherefore the opponent, that's me again, request this court enter an order to vacate the judgment of conviction pursuant to CPL 44030, and further that the court enter an order to renew pursuant to CPLR 2221, in the alternative that the court enter an order of dismissal with prejudice against the people. That's against the prosecutor. And I don't know why they call him the people, because the people don't really support him. Okay, now the response from the prosecutor to that paperwork was basically he say to the judge, they don't know what they're talking about, you should just deny it. And they failed to file an appeal within the proper time, and they were supposed to have 30 days, and they blew their 30 days for this. But in reality, what we're asking for, the law says can be asked for at any time. So even his statement to the judge, which the judge will say he's right, but we've looked up the law, and the law says at any time after you've been convicted, you can ask the court to rehear it and ask the court to overturn the conviction. Rarely do they do it, but you have a right to it. And the prosecutor's even saying, here, I only have 30 days, which is not true. But the judge is going to agree with what he says. Okay, now we have a right to rebut his response. We have more to rebut his response than just what I'm going to read you. This is our affidavit that's being added to the paperwork that's going to cite some law sites. And we, Joseph Barton and Paula Gloria Barton, being of sound minds and over the age of 18, sovereigns of the state of New York, make this affidavit of truth regarding our unconstitutional arrest December 22nd. Jurisdiction was never established.
2011.
At 1 p.m. If I left that out, she'd yell at me. Okay.
Lose more teeth.
All right, I lose more teeth. Anyway, in order for them to even bring you into court, they have to establish that they have jurisdiction over the subject matter, over what the subject is that's going on, and over you personally, that they have personal jurisdiction over you, which we argued from the beginning that they didn't have personal jurisdiction nor subject matter jurisdiction, which they ignored through every step, yet never answered it. They don't say, well, we do have jurisdiction based on this law, based on this fact. They never do that because they're tyrants. And the prosecutor just refused. When we say, according to law, jurisdiction has to be proven, they can't just say, we have it. No, they have to prove it. And we demanded that they prove it, which they never did. And the prosecutor wouldn't even answer it because our paperwork really put him on the spot to prove it, right? So he just never answered it, and the judge just said, I have it, which there's been many Supreme Court rulings that say a court cannot declare its own jurisdiction, and there's other Supreme Court rulings that say jurisdiction, once challenged, must be proven on the record. Now, they just ignore that, which was our Supreme Court rulings that we hit them with, and so they decided we're not going to answer anything that's constitutional. We're not going to answer any law that says stuff that we don't want to answer to. So they just don't answer to it and ignore it. So, and this is in my case, but I want you to know that this is what they're doing in every case that comes in this county. I really do not want you people out there to say, oh, Joe's just bitching because he got a raw deal. I'm not bitching because I got a raw deal. I'm bitching because the courts in Ulster County are completely corrupt, as probably most of them in New York State. And as long as you people just accept that we have criminal courts that can do what they want through sheer force, using the police as bullies to intimidate you and rip you off, and if you're not going to give up what they want, they're going to throw you in jail just because they have a power to do so, not the legal authority. Okay. from day one, we put our paperwork in that without a harmed party, there was no harmed party, there was no one that complained about me and Paula that we had violated them in any way. From day one, we put our paperwork in that without a harmed party coming forward with a case for action which relief could be granted. We, Joseph Barton and Paula Gloria, are the victims, we're saying. The police acted in an illegal manner, and that made us the victims. The real parties in interest who have been harmed. We did not enter a plea of either guilty or not guilty because we stated we do not stand under these charges. The minute you put in a plea of guilty or not guilty, now there's a contest. Jurisdiction has to be established or is established that there's an argument, so they move on with the case. And we know not to get ourselves in that situation right from the start. So I don't plead guilty or not guilty. All right. We did not enter a plea of either guilty or not guilty because we stated we do not stand under these charges. How can we be charged if we're the victims? That's what we were stating. And that human beings, not corporations, under a corporate jurisdiction, that we are not human beings under a corporate jurisdiction. We have a right to face our accuser.
That is human beings, not corporations, under a corporate jurisdiction.
Okay, I stand corrected. The original charging instrument is defective. That means that the original paperwork even that they used wasn't correct. Judge Jordan, this is all this is all errors that this judge has made. Well, we call them errors, only that's the polite way you say it in court, but in reality, he's acting as a tyrant and a criminal in a criminal manner, in an unlawful manner. Unlawful is criminal. When judges act unlawful, it's a real violation of their oath of office, and it's even more than criminal, it's treason.
But for a higher court, an administrative procedural error is just as strong as treason or all those harsher words, right? If they see error, they should.
Now you're getting in that. Yeah. Let's stay with the kind of arguments we got here and not go off into other. Judge Jordan erred by not requiring the prosecutor to prove subject matter jurisdiction and personal jurisdiction. See, remember I said the Supreme Court ruled when you challenge jurisdiction, it must be proven, and it must be proven on the record. Now, we challenged jurisdiction of the prosecutor to even bring us there and over us personally, and the judge allowed the prosecutor to not answer that and not prove jurisdiction. Without proof of jurisdiction, they didn't have the authority to move along further with this case. And that's the same with most of the cases that they bring before them. We challenged in our paperwork, Judge Jordan erred by not requiring the prosecutor to prove subject matter jurisdiction and personal jurisdiction, which we challenged in our paperwork and to which the prosecutor and the court failed to respond. The court declared jurisdiction, yet failed to prove on the record that jurisdiction was established beyond a doubt. Just because you say you have it, don't mean you have it. Forcing the case without no power of attorney. Now, we were giving him such a hard time about entering a plea and standing up and holding our ground on our rights to not plead since we were the victims, right? The judge decided he was going to put in the plea for us so they could continue the case and establish jurisdiction, which is a trick. But we said Judge Jordan violated our rights by entering a plea on our behalf against our explicit and written cease and desist. We gave a cease and desist to the judge stating, do not enter a plea on our behalf. All right, so I'm going to read that again. Judge Jordan violated our rights by entering a plea on our behalf against our explicit and written cease and desist from entering a plea on our behalf, as we have never given Judge Jordan a signed or even verbal power of attorney to act on our behalf. 4. In spite of our rejection, Judge Jordan forced lawyers to represent us, and against our specific demands that we did not want attorneys to represent us, as we would lose rights and become wards of the court whose jurisdiction we contested. So that's the trick they try to do. If they can put a lawyer on you, now it's a way to trick you into their jurisdiction, because if you need a lawyer to speak for you, then it's obviously you're not capable of speaking for yourself. That makes you a ward of the court, and now the lawyer and the judge and the prosecutor now have jurisdiction, and they can decide what they want to do with you. So jurisdiction is a very important point to argue if you go before these people, not that they're going to pay it any attention. All right, now the next section. Paperwork unanswered or paperwork improperly served. Judge Jordan erred by not forcing the prosecutor to answer our paperwork, but instead argued the case for the prosecutor, denying Joseph Barton and Paula Gloria due process and equal protection. So the prosecutor didn't answer any of our paperwork, and since he didn't answer any of our paperwork, in court, when you're in court, if you put an argument in and the other guy don't put in an argument, and then it goes to the next higher court, the only thing on the record is your argument. So your argument, since it's the only thing on the record, when it goes to the higher court, is supposed to stand as fact, right? And even in the lower court, if I put in an argument, if I say the prosecutor's full of shit, and the prosecutor don't say I'm not full of shit, then it stands on the record that the prosecutor's full of shit, and the judge should throw out the case on the fact that the prosecutor's full of shit. I'm giving it to you very simple terms here. I could give it to you in legal terms, but
It's better.
okay. So, if the prosecutor said I was full of shit and I didn't say I wasn't, then the judge would say, well, the prosecutor said you're full of shit, you didn't put up any argument, therefore you're guilty. Well, it always works when you go in these local courts that you're full of shit, but it never, ever, ever gets ruled by a judge that the prosecutor's full of shit. That's what we're arguing here, but I'll give it to you back the way we're doing it. Judge Jordan erred by forcing the prosecutor to answer our paperwork, but instead of accepting that the prosecutor was full of shit, Judge Jordan, but instead argued the case for the prosecutor, denying Joseph Barton and Paula Gloria due process. That was like I said, the prosecutor is full of shit, the prosecutor didn't answer me, and the judge said, the prosecutor is not full of shit. Now, is that an impartial judge, I ask you? Is that fair, a fair trial? Okay, let's move along.
In other words, when you cited memorandum of law to substantiate what you were saying, that he was full of shit.
Right.
If the judge comes back and says he's not full of shit, then he has to cite the law.
Right. He should even
That
cite
counters
the law.
why Joe said he was full of shit.
Right. And the judge didn't even do that. He basically said...
The prosecutor was full of shit.
Right. Because he couldn't say the prosecutor wasn't full of shit. He just bullied me, saying I'm the judge and I'm going to fight the case because he's too stupid to argue with you. Judge Jordan erred by Judge Jordan erred by being biased and denying all of Joseph Barton and Paula Gloria's motions and paperwork, and even argued against them while allowing the prosecutor to not respond and remain silent. So if the prosecutor remained silent and didn't argue any of the arguments, and the judge argued for him, and the judge was basically playing prosecutor from the bench, which they do all the time. I'm not just saying, oh, look what he did to poor Joe and Paula. This is what he's doing to every one of you when you go before him. only you're all too sheepish to stand up and fight these criminals. Judge Jordan is a criminal. I'm saying it live here on TV. And if he wants to, if he don't, take me on, sue my ass. I want to go to court with you, Judge Jordan. What's the judge in Socrates? Well, since we're taking shots at Judge.
Judge Lamb.
Judge Lamb is a criminal. I'm saying it here on live TV. If you don't like it, and if it's not true, sue me. Bring me to court. Judge Williams in Ulster County.
We're at it, Nina Pasterpak.
Right.
Wait until I get to my section.
Okay. Judge Williams in Ulster County is a criminal. If you don't like it, I'm saying it here on public TV. You can bring this into court. Sue me. I want you to. You won't get anything because I don't have anything, but sue me. All right. Judge Jordan has shown.
We're running out of cases?
Yeah. I'm running out of material for my television show. Sue me. Judge Jordan has shown clear bias from the very start of his being put on this sham trial after Judge Parker stepped off the bench. Judge Jordan again showed his bias when our last appearance in his court on February 21st, he allowed the prosecutor to say to us, "Have you received my response?" Which we stated we had not. Then Judge Michael Jordan denied us the right to see proof of service. We asked to see, well, if the prosecutor served us, we want to see the proof of service that he served the court, because I wanted to see the dates that it actually got served on the court, because we had never gotten it in the mail on time, and we were supposed to have it at least 2 days.
7 days. How can you respond if you get it only 2 days? I took notes.
Oh, that's right. We were supposed to have it 7 days before we went to court, and so we could respond to it before we went to court. And rebut it. That's what the response is.
But instead they wasted our time and they made another court date.
Right.
Just so blasé.
All right, but anyway, he allowed the prosecutor to say to us, "Have you received my response?" Which we stated we had not. Then Judge Michael Jordan denied us the right to see the proof of service, which we had a right to do, and he refused, showing bias. And in open court, Judge Jordan himself served us with these prosecutor's papers in front of many witnesses. Now, when a judge serves you the prosecutor's papers, how can he be unbiased? The judge is not supposed to serve papers for either side. It's so blatant, people. What I'm telling you, right? All this stuff is so blatantly criminal. It's totally ignoring the law. It's ruling as tyrants from the bench, doing anything they want to do just because they can't let you win.
Because why do you want proof of service? Isn't it obvious? I'm serving it to you.
Okay, now we're going to go on with this. Although he himself is supposed to be a neutral party, he served us with the prosecutor's papers, which is against the intent of proof of service and an error on the part of Michael Jordan. We use a nice word, error. I say it's a criminal act on the part of Michael Jordan, denial of due process, not being an impartial juror. The next day, February 22nd, we found mail from the prosecutor, which was postmarked February 20th. So if we were supposed to be in court on the 21st, and the mail was mailed on the 20th, there was no possible way that we could have got that letter on time to respond to it for court. But inside the envelope, it was dated the 15th. So he filled it out on the 15th, but they waited 5 days to mail it. That shows the slimy tricks that these guys will do just to win in court.
To try to give us the bum's rush.
Right.
He'll hear quick, take it.
Right.
Okay.
And he originally wanted to just start, oh, well, here's the paperwork, let's go on with the trial, without giving us a chance to respond, but I don't let him get away with that. And I said, wait a minute. We have a right to respond to this, to rebut his paperwork. That that he just wanted our paperwork, and the prosecutor saying, shoot down their shit, right? And that's basically all he said, without really put up any argument. I mean, we work on our paperwork, and we give them paperwork stacks like this thick, and these clowns don't do any of the work that a lawyer would normally do, and they just go, deny them because we don't like them, and we got a bar card, and you got a bar card, and everybody got a bar card, but they don't have a bar card, so just ignore their shit like it doesn't exist because they don't have a bar card and they're not one of the club.
Yeah, they throw around those numbers and sections and civil rights or civil procedures like
double talk,
like monopoly money, you know.
Okay, so 2000. So there was no possible way for us to have received service through the mail, as the prosecutor implied in court. So he's deceiving the court. If I went into court and implied and deceived, the judge would come down on me with a hammer. You know, the prosecutor also failed to respond in a timely manner, which Judge Jordan again overlooked. See, when the prosecutor does anything wrong, the judge just don't even pay attention to it. But you make the slightest error in your paperwork, and they're ready to jump all over you and throw out your paperwork because you didn't dot an I. You know, the prosecutor should be sanctioned for attempting to deceive the court. That's what we're saying, by saying, "Did you receive the papers?" If they were mailed on the 20th, the prosecutor obviously knew. Not only did we not receive the papers, but we were not allowed the proper amount of time to respond and rebut for a February 21st hearing. Sneaky little devils, aren't they? Color of law errors. Judge Jordan erred in not dismissing this case because the sheriff's department acted under color of law by arresting Joseph Barton and Paula Gloria Barton without a warrant, when the police officer had no knowledge of a crime. The officer also searched Joseph Barton's automobile without a warrant on the supposed smell of marijuana. The dashboard camera of Kevin Richards clearly showed the deputy sheriff arrested Joseph Barton and Paula Gloria Barton before, in fact, he had any knowledge of a crime, which made any evidence found after the fact the fruit of a poison tree. The fruit of a poison tree means that that evidence should all be thrown out. If the police act in an illegal manner to attain evidence, that evidence is tainted and can't be brought into court. And Judge Jordan knows the law better than me. He just chooses to ignore it. Before, in fact, a crime had made any evidence found after the fact, the fruit of a poison tree. And thus the evidence which Michael Jordan used to find us guilty, inadmissible evidence in court. Judge Jordan is now attempting to deny us our right to rehear our arguments or to appeal his null and void decisions to date by saying we have missed a 30-day deadline. In fact, the prosecutor's office had been informed in time of our intention to appeal, despite us not notifying the court, which we erred by not sending the letter to the court. But according to the law, you're allowed to, if you make an error, you're allowed to correct your error. Now, he won't even accept that we erred by, and its proof of our error was the prosecutor got the paperwork saying we intended to appeal. Now, we sent it to him. The letter to the court never got sent. But the fact that we intended to, and only an error kept us from mailing the letter, shows our intent. Therefore, that error, with proof of intent, should have been able to be corrected, which he didn't allow us to do.
Yeah, because court's not a place where you're supposed to get railroaded.
Right.
And that's the purpose.
Which again was an error we tried to correct. All through this farce they call a case, Judge Jordan has ignored constitutional arguments and Supreme Court rulings by overruling them with statutes and rules of civil procedure, which we have claimed violate our rights, so there should have been a hearing on all those, which we can show is an intention to make money off us as opposed to protect our rights or the peace of the community at large, through using unconstitutional laws that were never made into positive law. That means all these statutes and stuff, they're rules that they've made that they call laws, but they're not actual law. The Constitution is the supreme law of our land. Anything that goes against that Constitution can be challenged, is null and void of law when you prove that it is. And when you prove that it is, not only is it null and void for you, but it goes back all the way to the inception of that law, which they don't like to tell you that either. We can show in court not made into positive law at all, which we can show in a proper court of law. If we were in a proper court of law, we could prove everything that we've said. By Judge Jordan ignoring our constitutional arguments and Supreme Court rulings, he denied us due process, charging us not through positive law, but under color of law. Judge Jordan coerced, threatened, intimidated us into moving the case forward in a biased manner to get a conviction at any cost, including denying us due process, equal protection, choosing instead to protect the sheriff's deputy who acted under color of law. Again, this was obvious on the dashboard camera, whose failure on the part of Judge Jordan to give honest service is demonstrated by his not acknowledging what he saw in open court. Michael Jordan convicted us when he was obligated to dismiss. Throughout this sham trial, which we claim is null and void, Judge Jordan made law from the bench, which is illegal, prosecuted from the bench, which is illegal, served the prosecutor's paperwork from the bench, which is illegal, allowed prosecutorial misconduct, he allowed it, which is illegal and on his part, failed to give honest service. He failed to do what we as a people pay a judge to do, to give honest service. When they don't give honest service, they fail in their duty to the people. Abuse of judicial authority. Not only did he fail to do the right thing, but he abused his place as a judge when he overstepped his bounds. Violated his oath of office. What we're saying, and violated his oath of office. He swore an oath to protect and defend the Constitution. And in doing so, he's supposed to protect and defend all the people who come before him's rights. When he failed to do that, he violated his oath of office. And when a judge violates his oath of office, that is treason. And he denied us due process. For these and the arguments listed in all our paperwork that was served to the court and ignored, we moved this court to rehear this case and correct the injustices by dismissing this case with prejudice. Now, of course, he's going to say, we see no reason to rehear this case. As the prosecutor said, everything you did was wrong and in error, and actually we know everything we did was right.
Denied in all aspects.
Right.
Kind of deal.
Right. Go ahead. You want to do yours?
Okay. Here's my version. Basically, I just have a little bit more at the end. And what I did was, I took my Gramercy Park co-op lawsuit. I call it a false foreclosure, but I'm thinking of renaming that as bank harassment, because the more you learn about the fraud and the more you understand the trust accounts that were set up for us when all of the gold was embezzled in the 30s, and we had no recourse except to use the Federal Reserve note, which was supposed to be internal currency, only to be used by the Federal Reserve. But that was the Federal Reserve Act was in 1913, and by 1933, when all the gold was embezzled, they had to collateralize the currency with the future labor of the American people. In return for a mother giving a child over for a birth certificate for his share of the commonwealth, the understanding is the child has to have access to a trust account. In other words, when they're betting or when they're saying that the value of the currency is determined by the full faith and credit of the American people, clearly you have to take care of the American people. So when the American people are born, they get a birth certificate, and that means as they grow up, when they need a house and things, you go down to the bank and you think you're borrowing money from the bank. But what you're doing when you're going down to the bank is you're signing a document that then allows the bank to go down to the Treasury Department and cash it in for credit. Then what they do is they trick you into signing another document because they know you don't know this. So as far as you're concerned, it looks like you're getting money from them, and that if you don't pay that money back, they are going to be the harmed party. But in truth, it's just the opposite. You're the undisclosed third-party creditor. So this is the truth. This is the big inner secret of all the law firms, and this is the kind of thing that the big multi-million-dollar settlements, when the money goes back and forth, basically it's to sort of keep the whole scam kind of under control and keep everything quiet. So as people figure this out, or I guess different law firms kind of jockey for position, for access to the judges and whoever it is that keeps this in place. And I don't want to say also, Joe was saying that the courts are using the police to protect them as if the courts control the police. It may in truth be the other way around. But for all practical purposes, several years ago, eminent producer lawyer friend of mine helped me put in some paperwork, which I realized later was pretty boilerplate for a key change, a key lock change. And once that paperwork was filed, it's true, what started coming in were all these insurance companies saying that all the insurance was off. So that kind of makes you think you're on the right track, that if you've got a case that's so good that the insurance companies, because, the boards and the management companies have to take out insurance it's part of risk management for being, getting sued. However, if rights are violated, all bets are off. So this shows you how powerful rights are. So there was some verbiage in here which, if you thought you were just a deadbeat, non-performing tenant who's not paying, then you think it doesn't, it's a little bit excessive, and wow, isn't that amazing that you got such a good lawyer that you got your $2 million. But if you actually start to study it in light of the deep law that Joe and I are studying, taking into account the bankruptcy of 1933 and the Federal Reserve Act of 1913, with those Federal Reserve notes only supposed to be being used by members of the Federal Reserve Bank. But by the 1933, when they're making gold illegal, there was nothing else we had to use for why you need money, because you can't be bartering on everything. So I want to break down these boilerplate terms, and just like when I was reading from the lawyer in Greece on my family's will, I've got what the lawyers say and what I say. So here's what I'm saying. Over a year has passed since this abusive act against us by the Sheriff's Department and Hurley Court protecting the abuse, and still we, Joseph and Paula Gloria Barton, feel harmed tremendously. And then here's the boilerplate stuff. Causing us permanent harm, including but not limited to having been profoundly hurt. Now I think the actual verbiage they had was permanent injury. Injury, I heard, is a term more used for corporations, and harm is for physical bodies. Okay, now here's my stuff. Well, actually, I'll read it how it usually goes. Having been profoundly hurt, aggravated, insulted, cast in a false light, degraded, discriminated against, humiliated, threatened, menaced, persecuted, deprived of equal rights to constitutional and legal protection, and caused to experience deep mental trauma, extreme anxiety, profound shame, extreme embarrassment, humiliation, degradation, discrimination, threat, menace, fear, uneasiness, anger, and extreme and long-lasting emotional distress. So now what I want to do is show exactly how relevant all of those terms are. Okay, causing us permanent harm, including but not limited to having been profoundly hurt, and I'm saying my words, by the excessive physical force of Kevin Richards so brutally dragging me, Paula, Gloria, out of my husband's automobile. My words, okay, their word. You have something to say?
No, God, you're doing
okay,
wonderful.
their word aggravated, or the boilerplate word for which millions of dollar settlements have been happening, aggravated. Now I'm saying by not knowing which laws we are going by to determine who the real harmed or harming parties in interest are. Those that have actually been physically, mentally, psychologically harmed like ourselves on our physical, psychological, and spiritual bodies, or those parties that have caused harm for profit on us. And we turned paperwork in on the CRIS report. That's Court Registry Investment System. So we're proving that these courts have Dun & Bradstreet numbers and that every indictment is traded on a bond market.
Let me jump in on that one just for a second, and then you go right back. What she's saying there is all these courts make money off us coming in there, and we've said on past shows how they make money, so I'm not going to go into a long thing. But just to point out what she's pointing out in her paperwork, these courts profit off convictions from us. So there's no chance of getting a fair trial, and in these kangaroo courts where they decided right from the start, before they brought you in, that they were going to find you guilty, because if they don't find you guilty, they lose money and you can sue them. So that's the reason why you'll see prosecutors saying, oh, I have a 98% conviction rate. Well, can you really believe that 98% of the people that go before this prosecutor, and you got 10 prosecutors all saying they get a 98% conviction rate? Can you really believe that there's justice in our courts? It's all about them making money and profiting off the slavery of the American people. Go ahead. I'm sorry.
The irony is
Go back to it.
But the irony is that the defense lawyers, even if you hire your other lawyer, you still get convicted. That's the thing. Maybe you get a deal. I think that's what they talk that down. But anyway, okay. Insulted is the boilerplate word. I mean, when I say boilerplate, what I'm doing is it's just
that's standard words that when lawyers sue, they use these standard words. That's what she means by boilerplate. All the lawyers use the same. They got little plates that they can pop it out of the computer and say, oh, I just got to move a few words here,
right,
and here it is. That's boilerplate.
Right. They jimmy it up a little. Okay, so the word is insulted. Okay, and so I'm saying the excessive physical force of Deputy Sheriff Kevin Richards on Paula Gloria's body in front of her husband, who helplessly looked on, and also because the prosecutor doesn't answer our paperwork. You know what I'm saying? When somebody doesn't answer you and you're speaking, that's a really degrading kind of experience to have to go through. Here's their word, cast in a false light. This is a very interesting word. And I said, because we are not corporations, and because treated like criminals for our religious beliefs. Okay? That's why we're cast in a false light. You want to say anything on that?
No, you're doing good.
Okay.
We don't have a lot of time, so I want you to finish.
Okay, degraded is the boilerplate word. Okay, degraded, to be dragged through the courts which deny due process, and because the judge doesn't think we need a bona fide proof of service to be served properly. That's degrading. Discriminated against, that's their word. Because the prosecutor doesn't answer when I say that's their word, I mean that's the word of these systems. Okay, because the prosecutor doesn't answer our paperwork and we don't deserve a proper proof of service is extreme discrimination. Humiliation, because we had our names in the newspaper saying we have been arrested and having to explain to our friends and people in our community who we constantly asked to come with us to court, but before whom our community of peers we cannot get from public servants who have taken oaths to protect the Constitution clear answers about the purported laws of our land and why these laws are in truth harming us and not protecting the community from crimes at all. Their word, the threatened. Because even when we go to court, one of the charges for obstructing governmental administration, initially a felony, was never even addressed and carries a long sentence with it. So how can we be assured this charge will not come up again in yet another kangaroo de facto court? Well, I didn't say kangaroo in my paperwork, but I said de facto. Their word menaced. Menace. The menace of partial courts is obvious. Persecuted. Excessive physical battery to drag me out of my husband's automobile when I was just a passenger. Deprived of equal rights to constitutional and legal protection, the boilerplate word. Laws are used against us when it suits for the profit of the courts, but ignored when we require these laws to prove we are the harmed real parties of interest. And then their word, and cause to experience deep mental trauma. And then I'm saying, to not be able to face our real party of interest accusers. The right to face your accuser is really important. And that's what proof of service is all about, because when you're served something, you can find the process server, bring him to court and say, who gave this to you? And then you start to get the human hand trail, and you reach into the corporation, and you find out who's been misusing the corporation to hide this theft. Okay, extreme anxiety, their word, due to the arbitrary nature of how the laws are used and not knowing why, if we have harmed no one, we are being dragged into courts fearing that otherwise highway robbers, known as the Sheriff's Department with bench warrants, that Judge Jordan said he would issue if we did not appear in court, will come after us, and how we can be assured the obstructing governmental administration charge will not come up again in yet another de facto court of limited jurisdiction. Profound shame, the boilerplate word, people thinking we are criminals for breaking unconstitutional laws. So keep in mind the Constitution wasn't set up to where the legislature pits the people against these hidden interests. But they use it that way. They say, well, write your congressman and change the law. The law is unconstitutional right now. Extreme embarrassment. People thinking we are criminals because our innocence is never addressed, because we can never get a clear answer from this court. They start to cast us more and more into a false light unless we fight it back with public access and teach people the law, teach people how to think this through. Humiliation, the boilerplate, word that got millions of dollars for people in other cases. The prosecutor never answering our paperwork completely, ignoring the important issues of the intent of the law, is a major put down. Degradation. We are just sheep to be shorn with no rights, as this whole process is just about money. Discrimination. Laws are used one way for our side of the fence and another for whoever benefits from the profit these court businesses take in. Threat. The Foreign Sovereign Immunities Act, along with no real party of interest that has been harmed, shows that Judge Jordan's court is foreign to our way of life as a free people, and we are under threat of tricks to deceive us out of our right to face our real party of interest accuser or accusers, and we are threatened because of bench warrants issued if we do not comply. Menace is their word again. The menace of unjust courts is self-evident. Fear, not knowing when another warrantless arrest will come again, and of arbitrary laws. Keep in mind, my husband on many occasions has had police, SWAT teams come in without warrants and shaky guns. Like he says, he's more afraid of the police pulling the trigger out of nervousness because they don't really know how to handle the weapons, or I think they don't really feel that righteous behind that gun. And if you look into...
And they're so pumped up on adrenaline. Right. They have such fear when they come through your door that there's a good chance you getting shot just because they're afraid. They know what they're doing is wrong, busting in someone's house, and that person does have a right to shoot back at them, so they're all afraid. Even when they come in on peaceful hippies, they know are unarmed because they know me. They knew who I was before they came in, yet they still came in with big clips in their gun. All you people out there are saying, take away the guns, take away the guns. We don't want the big clips. All these SWAT teams have the big clips, people. Go ahead,
Exactly.
go on with your thing.
Exactly, okay. Okay, uneasiness, not knowing if we are really free. That makes you uneasy. All your life you're brought up to believe in this Constitution that you're free people. To find out clearly you're not makes you really uneasy. And unless you experience this, go through this, or pay attention to shows like this, you're just going to live in an ivory tower. You just don't have a clue. And all your university professor people, the same problem. Okay, anger at Kevin for stealing from us, and anger at the courts for protecting such theft of property. Okay, and extreme and long-lasting emotional distress. This trauma, these are my words, this trauma never leaves. No money can compensate, but a good I am sorry from the real parties in interest who benefit from the profits these courts steal from ignorant people would be a step in the right direction. Please let's not kid ourselves. Marijuana or cannabis, as its correct name is known, is one of the world's most healing plants for many, many diseases, and it can be grown in anyone's backyard. Because of this, big pharmaceutical companies, the natural financial allies of the banks that have devastated our country with physical and psychological warfare, as expressed in the brutal arrest of Paula, Gloria, and Joseph Barton, do not want free access in the community they could otherwise charge for this valuable plant. And as I, Paula Gloria Barton, said in court, why should I be denied a cure for cancer just because I am poor? I want to say at this point, I'm going to correct this paperwork and say just because I don't have a lot of Federal Reserve debt notes. In that respect, I may be poor, but you know, wealth, real wealth is not calibrated by debt. That's the important thing that the Founding Fathers, okay. This disregard for all our paperwork, the total ignoring of answering positive and long-standing law, and refusal to give honest service by public servants who ostensibly take an oath of office to protect the people and not special interests is shameful and should be corrected by dismissing this case with prejudice so we can all move on and create a nation we are all proud of.
Okay. Now, I want to go on to tell you people, what all we've told you and showed you is that these courts are acting in a criminal manner. These courts are not making law fair, where both sides have equal protection under the law. They play all the way to the prosecutor, and they act in a manner that is actual criminal manner. These courts are corrupt. They're criminal organizations. They're there to make money, to fleece you, to take your pockets, to pick your pockets. So we want all you people out there to start getting active, because if we don't change the laws and we don't change the courts, then there is going to be no justice, no chance for us to straighten out the problems in America. Have a good night from Joe Barton from Pot Talk TV. See you next week.
You've been watching Pot Talk 2013. Video update pending. Starring Joe Barton. Also starring Paula Gloria. Be sure to tune in next week at this same time on this same channel for more Pot Talk TV.